A good day to you all. My name is Mufaro Tewende, a second year law student at Africa University. Today I'm going to present to you on privilege in the law of evidence. So basically, we are going to talk about the various forms of privilege that are found in the courts of Zimbabwe and in the law of evidence. So we are going to discuss on the private privilege, the public privilege, as well as other various forms of privilege that fall under these two main categories. So by end of this presentation, one must be able to define first what is privilege in the law of evidence. Secondly, they must be able to define public privilege and private privileges, as well as to annotate the differences between these two these two privileges. Apart from public and private privilege, they also must be able to understand the various forms of privilege that fall under these two major categories, namely the privilege against self-incrimination, the marital privilege, the legal professional privilege, the parent to child privilege, the state privilege, and they must also be able to refer to case law as well as the criminal and procedure, the Criminal Procedure and Evidence Act as their authority to understand these types of privileges. They must also be able to understand exceptions where privilege might be claimed or might not be claimed. So this is basically what this presentation is going to talk about. This being said, we are going first to define what is privilege in the law of evidence. So, privilege is a rule that it is a rule that excludes both individuals or public organizations. By public organization, I mean the government and the body that constitutes the government, whether the army or whatever you may think of that is under the public interest segment or the public sector of the government. So it is a rule that excludes these entities from presenting or disclosing certain information that is relevant and admissible in courts. So under privilege, uh, witnesses or one is not bound by the courts to present certain information on the basis that there is a higher interest that needs to be protected. There is a high interest that needs to be protected by not disclosing such information. So it is sort of a right not to disclose such information. It is a right per se, and it is also a right of, according to the Zimbabwe Constitution, to have sort of privacy or protection to dignity and yeah, to dignity or your character. I don't know how you are going to how I can explain this further, but pretty much so. So that is privilege. So privilege is basically categorized into two. That is the public privilege and the private privilege. First of all, we are going to define what is private privilege and what is public privilege, as well as to annotate the difference between the two. Um, Private privilege refers to a rule that excludes individuals who are not part of the government or who do not work, not per se who do not work, but whose information does not link to the public, to the interest of the public. Let's say their information or their interests, they are of purely personal capacity. So private privilege is a rule that sort of excludes or restrain these private entities from disclosing information which in most cases is relevant and admissible in courts, but it is of higher interest. So to prove that this information is of higher interest and these individuals are not just holding or withholding this information so as to protect themselves, the courts have to look at other circumstantial evidence to prove that there is no need to protect to their own interests, which are not legal, or not to say legal, but which are not of higher importance than that of the case which is in trial. So, under private privilege, it is the individual or the legal representative of that individual who can claim the privilege not to testify, right? That is, and it is also up to the individual to waive their privilege. By waiving, this is whereby they say, I no longer need this right not to testify, and I'm willing to testify um, in court. So in the event that the individual is waived their privilege, there is no other way they can retain it back. They will have to testify. In this sense, now they are sort of compelled, since they had the chance not to testify and they willingly uh, dropped their right not to testify. Public interest, I'll explain it when I'll explain state privilege later on. So there there is the, there is also other constitutes of private privilege. I mean, these privileges that fall under private privilege. One of them is privilege against self-incrimination. So this is a privilege that refrains one from testifying against themselves. Uh, in court proceedings, there are instances where one might be sort of compelled to testify against themselves. So it is a right of any persons or individuals to claim that they do not wish to answer any questions, or to just give information that might be of interest to them and is legally approved by the courts to be of higher interest and importance than the case that is in trial. So there are instances where where this information can be testified though. That is, if the person who is being asked to disclose such information gives full consent, which is not biased or sort of forced out of him or her. In that scenario, the individual can testify. Then another thing to note under privilege against self-incrimination is it is the duty of the judicial officers to notify these individuals that they have the right not to testify against themselves. And there are also exceptions whereby if one does not know that of this right, they cannot be held liable of anything which the court might be held on. Let's say in the case of S versus Luane, the appellant had confessed of participating in a murder while testifying as a complainant against a fellow thief and a murderer who had shot him, which led to his conviction on the charge of murder. On appeal, it was ruled that his confession was inadmissible in court as he was not aware of his right to decline or to incriminate himself in the presiding of and the presiding officers had not notified the individual that he had this right. So the judge further explained that the presence of a legal representatives does not exonerate the presiding officer's duty to ensure that their witnesses are aware of the right not to testify against themselves. This being said, we also have to note other exceptions where this rule, whereby one is compelled to testify against themselves in court, that a witness' privacy is invaded or disgraced or rendered infamous, notorious, let's say embarrassed, embarrassed, or that the witness suffers patrimonial loss, which is discussed in delete. Patrimonial loss, the event that they feel they will be embarrassed by disclosing such information will not be tolerated by the courts per se to grant one this privilege against testifying against themselves, or the fact that they are a subject to civil liability will not be be tolerated. The case of Regio versus United States is another case law which is relevant to that assertion. So, unless the representatives is asked against themselves or either through their representatives to or either through their representatives to testify against themselves, then they cannot be liable or be compelled to testify. Um, this being said, let's move on to another another type of privilege, which is the the marital privilege. So the the marital privilege is the marital privilege it is a the marital privilege is a rule that excludes spouses, whether legally or what can I say, legally or not legally married, but living together as husband as wives, from testifying against each other. So this privilege, in a way, protects the confidentiality and the privity of marriages. So by one spouse might not testify against the other. Let's say the husband. The husband is he has the right not to testify against the wife. That is, if the information was shared between the two between the two spouses who are in this case living together as husband and wife. So the fact that you are not married according to marriage the marriages act does not the fact that you are married according to the marriages act, or whether under registered or unregistered customer law, does not exclude you from will not be held valid as a reason for one to be compelled to testify in this court. Let's say I am married in an unregistered customary law, and even we are not married, but we are just living together as husband and wife, and we have our own family. As long as I have that concept of husband and wife, as long as that ingredient is within the confinement of our house, and we are living like that, then we are able and we are entitled to the right of not testifying or disclosing any information, whether it is relevant and admissible in courts, to against my partner. That is what the marital privilege is all about. So marital privilege also has an exception. Let's say a third party that is not part of the the marriage. He is something that might be of interest to the court, that might be of relevance, can be admitted in courts. They can testify against they can testify against the spouse, because they are not bound by the privity or the sanctity, let's say the sacredness of the wedlock. I didn't want to use the word wedlock per se, but the the union of being husband and wife cannot bind the third party who is not part of that union. So they can testify against the married couple, and yeah, that is it. So um like I said, a husband is not entitled, then that's why it is called spousal marriage. In a spousal marriage you cannot testify. um According to the Criminal Procedure and Evidence Act, Section 292, no person shall be compelled to answer any question or to give any evidence if the question or evidence is such that, under the circumstances, the husband or wife of such person, if under examination as witness, might lawfully refuse and could not be compelled to answer or give. Like I said, this rule is no exception where a third party can be compelled not to testify. A third party can come and testify against either the husband or the wife. So there is relevant case law to to that. That is the case of Ace versus Hammers and others. Moving on, we are going to the parental privilege. So the the parental to child privilege is another privilege which is used in court proceedings, both civil and criminal court proceedings. So the rule is sort of not widely used in Zimbabwe, but according to my researches in South Africa, uh, the South African Criminal Procedure Act makes it clear that it is possible to force it is not possible to force parents or guardians to testify against their children. Uh, Not only parents are compelled not to testify against their children, but also the children as well are not compelled to testify against their parents. In the event that the parent goes to court, um, who the parent goes to court in a criminal proceeding or a civil proceeding as a representative or a supportive partner to the child, uh, the parent cannot be compelled again to testify against their child because their reason to go to the court was not to testify but to provide assistance to their mind to their children. Let's say they are the children are minors, not majors. By minors we mean children who are under the age of 18 years according to Zimbabwe. So this is one of the cases. There is the case of S versus M, a case of 1932. The appellate division stated that Section 73, subsection 1 and subsection 2 of the criminal procedure granted a right upon minors to be assisted by their respective parents or guardians from the time they are apprehended by the police, as the same way a major may be entitled to the assistance of a legal representative. So, due to the fact that the parent is given sort of the same position as a legal representative, they cannot testify against their child on the basis of confidentiality, which I'll further explain when I'm talking about the the legal professional confidentiality. Um, Subsequently, a privilege not to testify against your own offspring or a minor against his own parent is observed and must be venerated the same way illegal professional privilege is done, like I said earlier on. By this precedent, which I have read from S versus M, the 1932 case, the position which the parent is given is the same position that the legal representative of the same minor is given, because they all go to the court in the event that they are providing assistance, though it might be in different segments or professions or duties per se. It is of the same importance in terms of its caliber. Yeah. So that's basically what's under the parental and the parental to child or child to parent privilege. Um, Now we are going to look at the legal professional privilege. So the legal professional privilege is it is a it is a privilege that is recognized in Zimbabwean courts as well as in South African courts as a mechanism to exclude persons from giving evidence in court that is shared between their legal representatives or their lawyers in themselves. It doesn't matter if it is bad in courts according to the law or not, as long as it is shared between the legal practitioners and the their representatives, their clients. There is the degree of confidentiality which refrains or restrains both parties to disclose such information, whether it is relevant or admissible in court. So, the Criminal Procedure and Evidence Act states that no lawyer or legal practitioner rendered fit and proper to advocate in courts, whether Zimbabwe or abroad, shall disclose any evidence against their clients or those he consulted without the approval of that person. The relationship between a lawyer and his client is confidential, like I said earlier on. So, in order for a lawyer to disclose information that he or she discussed with his client, there is need of consent or approval from this client to to disclose such information. It is also part of the regulations of the Legal Society of Zimbabwe, to guarantee confidentiality between the lawyers and their clients, whether the information is criminal, whether it's legal advice, it's whatever information that is shared between those two, or be it criminal in nature, let's say it's illegal in nature in courts, there is no need to disclose the information based on the normative ethics of the legal profession, particularly in Zimbabwe. So the only exception that is there, to not to say the only, the exception that is there that only permits the legal professional privilege to be sort of wavered down is through the consent of the client. So there is another scenario. Let's say I, as a lawyer, used to present someone. Let's say X. I used to represent X earlier on, back in the day. So when I used to present X, the information that was shared between us cannot be disclosed as evidence in the courts, even after, or let's say, my contract between X and I expired, or we are no longer partners, let's say professional business partners. In the event that we are no longer in business of exchanging such information, giving each other legal advice, there is no room for me as a lawyer to disclose such information. in the event that the confidentiality is sort of a, a normative